It is 6 o'clock, so I think we're going to get ready to go. Good evening, everyone, and welcome to the second webinar in the Women's Advocate September webinar series, Navigating Housing as a Survivor. This webinar is going to be sort of a collaborative effort between women's advocates and Common Bond communities. Our primary presenter during this webinar is Kristen Falston, who is the Regional Manager of Common Bond Communities. And Kristen will be supported with commentary and interesting facts and tidbits by myself, Mary Beth, and Nisha and Ani, who are also housing advocates at Women's Advocates. So I guess let's get started. All right, so if you have attended any of our webinars in the past, this particular slide won't be new to you. We like to begin webinars here with just a deep breath. We can all take a collective breath together to sort of center ourselves in this time and this place. You can use the graphic on your screen as a guide for 4 seconds, the box breathing. I also want to remind everybody today that domestic violence can be really difficult to talk about, obviously. It can be difficult to learn about and discuss, so do what you need to do to take care of yourself during this webinar. If you're having trouble at any time, you feel free to step away, seek some support. You can message me privately in the chat. I'm a crisis resource advocate, can go through some of those feelings with you. I also want to name at this time that all violence is interconnected, and police violence against Black people needs to be a part of these conversations. It is crucial for us as advocates to understand how domestic violence can impact the Black, Indigenous, survivors of color, and in general, and especially those who have experienced violence from the police. It's essential for us to continue to incorporate racial justice into our work. I also want to hold space today, I think, as we're spending time discussing housing for domestic violence survivors. I think it's important that we hold space for our unhoused neighbors and houseless neighbors who are gathered in encampments across the metro area. If you're tuning into this webinar from anywhere in North America, chances are you're tuning in from stolen and colonized land. This summer in the Twin Cities, we've seen multiple violent evictions of encampments by law enforcement and little action by the government to provide people with safe, permanent housing. As we talk today about housing barriers for domestic violence survivors, we need to actively work for housing solutions because no one should be evicted on stolen land. And with that, let's go. So we're here at Women's Advocates. We are a domestic violence shelter in St. Paul, Minnesota, and our mission is to walk with victim survivors and our community to break the cycle of domestic violence. We were one of the first domestic violence shelters in the nation. We were founded in 1974. And we provide prevention and education, emergency shelter for up to 50 women and children at a time, a 24-hour crisis line, and aftercare and housing support.
Nisha and Ani, would you like to introduce yourselves?
Sure. This is Nisha, and I am one of 2 housing advocates at Women's Advocates, working with the women in the community once they leave shelter to help them create self-sufficiency, do budgeting, and any other goals that they may have that they'd like to meet while we're working together.
And I'm Ani Broadcourt. I am the other housing and aftercare advocate. Yeah, meeting women where they are and joining their journey for housing.
Great. Hi, this is Kristen Kowalston speaking. I am really grateful to work with women's advocates on this project for cross-training and sharing information and resources between domestic violence advocates and property managers and owners. I have personally learned so much from the advocates, and it has allowed me to better support the managers I supervise through domestic violence situations. I've also come to understand how unique and complicated each situation is, depending on the needs of the individuals and families that you all serve. So I want to thank everyone for the work that you do and for taking time to be here this evening. A little bit about me. My current position is as a regional manager with Common Bond Communities, and I oversee a portfolio of 14 properties, including tax credit, Section 8, and supportive housing. I also want to give a disclaimer that I am not a lawyer and I'm not qualified to give legal advice. So my main goal of this presentation is to review a lot of the common barriers that you find in supporting the clients you serve in finding and maintaining stable housing, and to help give some tools and advice on how to navigate those situations. Although I will use some examples of lease language and documents from some of the properties I oversee, the information I'm presenting is general housing practices and not necessarily a common bond policy or procedure. And I've tried to make it broad to encompass a lot of the various types of housing. One thing I wanted to mention too is that Brenison will be taking polls throughout the presentation to get an idea of the information that will be most useful to the group. So some of this info is basic information, and if we can go over that quickly, we'll try to do that. So we're just providing the most useful information.
So we'll launch that first poll here. What best describes your role in the community? And you can select multiple options as well. Or if something that you feel you do is not represented here, you can write it in the chat.
All right, this is Mary Beth again. It looks like we've got poll results up with most people evenly split between domestic violence advocate and other social service provider, as well as we've got a couple of other things as well. So again, if you don't feel that you were represented in the poll, feel free to put yourself in the chat. All right, so for the next 2-ish hours, this is sort of a roadmap of where we're going. We'll talk a bit about the barriers and solutions to stable housing. We'll talk about briefly the types of housing, the market rate, Section 8 subsidies, all of that. We'll dig into the application process, talking about relevant laws in the housing infrastructure and domestic violence. Then we'll go do sort of a deep dive into housing and domestic violence and sort of what happens when those two systems collide.
All right. We wanted to touch on the impact of COVID-19 on housing. And just to note a couple of the specific rules right now. The governor did sign an order to suspend evictions. However, rent is not reduced or waived during this time. And that's an important distinction too, because I've heard a lot of misinformation from people that they have that they have been informed that they don't need to pay rent or that rent isn't due at this time. Another piece of information is that evictions can't be filed. There are situations where property owners can bring an eviction to housing court. And it's specifically, there are only certain things that will be allowed to proceed as an eviction. And I don't know the specific details on that, but typically they're related to safety and issues that would potentially put other residents in danger. So if you're supporting someone who has that has had an eviction filed against them, there are some resources included on this slide. They can contact the Attorney General's office in Minnesota. They can also contact, a legal aid or legal assistance. Homeline is a great resource for help for residents in Minnesota. And then for rental assistance, 211 or United Way is the easiest and best resource for rental assistance. And there's also a toll-free number and a local number for them as well. And I think we have another poll.
Yeah, so this poll is just talking about the ways that COVID-19 has impacted housing for the survivors that you have worked with. If something that you've seen isn't represented here, feel free to write it in the chat. All right, so we have the poll results up, and housing options are limited is definitely the most common result. The winner of the poll. Maggie's also written in the chat that it is hard to find affordable housing, especially now. And that's one of the ways that COVID has impacted housing for domestic violence survivors. Christine says legal aid is so backed up with requests that clients are sometimes able to get a response back. I can't imagine. All right, so those are the poll results. Let's take a little move on. Oh, Nisha and Ani, sorry.
Nisha and Ani had anything to add about their experience in working with the housing, the aftercare participants during this time, if there's anything you want to share.
Yeah, this is Ani. I can add that I have experienced that some of the extra COVID assistance, because it's very specific to people who are behind on rent or behind on utilities, hasn't applied to some of the women that I'm working with because they've managed to stay not behind, but they've still had hours cut because of COVID. So they're kind of those people who are just sitting on the edge, and some of the assistance that's offered hasn't quite applied to their situation. So we try to stay creative and hopeful and just support and affirm that they're doing a great job staying ahead and staying on top of things, even in really challenging circumstances like COVID-19.
I agree. This is Nisha. And I also want to say, as soon as we get information about any assistance that may be available for any family that's impacted by COVID, we do send that information out to most of the women, and usually they're on top of it if they do need it.
Thank you both. Yeah, it's really important during this time to get creative. And so now let's, Nisha and Ani, in that end, do you want to speak to any of your experiences or bring any insight from working with people who are in specific communities for folks who hold marginalized identities?
I'm sorry, Mary Beth. I'm going to pass on
Sorry.
that question. That's okay.
Yeah.
Yeah, I don't have anything specific to add. This is Ani. I'm really grateful that you put up those resources. I'm a big believer in person-specific healing and things like that. It's not something that I, as a white woman, am always able to offer. But recognizing that they're going to have a very different experience is important, and connecting them with resources that feel more appropriate to them as best we can is always what we try to do.
Yeah, and especially now, the way that Black and Brown and Indigenous communities are so much more likely to be affected by COVID, and also so much more likely to be affected financially by COVID. It's important that those resources exist. All right, moving on now, let's talk about in the poll here some barriers that to housing that domestic violence faced. Go ahead and answer, select as many as apply to you, or the survivors that you have been working with. Again, if you feel left out of the poll, please put it in the chat.
And this is the interpreter. We're going to switch and spotlight the other interpreter at this time.
Interpreters, we're ready when you are.
Thank you, interpreter. And now let's take a look at the poll results here. Barriers that domestic violence survivors have faced to housing. We've got poor credit really in the top one, but also ruined rental histories, loss of subsidized or affordable housing, or lack of steady employment, all pulling in the top categories. Barriers to housing in the chat, Yulia says, if the survivor has left her home due to domestic violence, yeah, leaving your home is definitely a barrier to housing. So just a few of the barriers survivors are seeing.
So the first section we're going to cover is finding housing, and we're going to talk about some of the barriers to finding housing, common screening criteria and tenant selection plans, tips on looking for housing, and if housing is denied, then requesting an appeal to have a reconsideration made. I think we can go to the next. Oh, okay, yeah, thank you. No, sorry, let's go back. So this has already been mentioned, and I just want to recognize it, that there is an extreme lack of affordable housing. There is a crisis in that, and finding housing that is truly affordable, even when it's called affordable, is really hard to come by. Within the different types of housing, there's tax credit housing where there are income limits, where typically people have to be below 30%, 50%, or 60% of the area median income. Section 8 housing is where the rent amount is based on their income. And Section 8 housing is challenging to come by, and there's usually a pretty significant waiting list to get into that type of housing or to get a portable voucher. I also want to recognize that the various financing in affordable housing creates barriers and criteria that's specific and unique to each affordable housing development. Some of them with tax credit rules and Section 8 rules apply to all of the various states, but each state also has specific affordable housing financing that comes with its own criteria. So we're going to look at some of the key documents that will hopefully provide information to you prior to having someone apply for an apartment, and then look at navigating denied applications. So we have another poll on this slide. What about the housing search process is the most challenging? Okay, we have the results. Not knowing where to look is challenging. The lack of affordable housing is absolutely an issue. Safety concerns, searching for a location abuser won't know about or doesn't currently reside in. And needing housing sooner than is available for safety reasons, application fees, application approval time, and let's see, is there something else in the, oh, survivors who are in a divorce process that do not qualify for affordable housing but have a very low income. Yeah, those are all, you know, significant barriers to overcome among, you know, many of the other ones that are out there. So it sounds like securing housing quickly and knowing how to navigate that application process will be things that we should focus on in this section. So yeah, let's go to the next slide.
Hi, this is Nisha. Can I jump in really quick on that last slide in regards to challenging things as far as housing goes? It wasn't on the poll from what I saw, but one thing that I usually encounter when it comes to applying for places is a lot of their rental criteria, and credit score has been a huge barrier for some of the women that we work with, along with income, but the credit score has a huge impact on them as well.
Yeah, definitely. This obviously doesn't apply everywhere, but the city of Minneapolis has made changes with respect to that. So now I'll get to a slide that goes into more of the specifics there. But as far as the application goes, there are some questions that you can ask up front before even going to look at an apartment during the call phase. Finding out what the application fee is, how much the deposit is, if a deposit is required to hold an apartment, and you know, what types of things they look for when they're screening an applicant. Yeah, I think that's, so part of navigating this process too is really knowing and understanding what is on the public record, credit score, and things like that. And then if potentially there's one item that might not pass the criteria, then I think it's important to ask if they have an appeal process if an application is denied. Another tip that I had on here was to contact previous property owners, managers, and find out what type of rental reference they would give, and just ask directly if another potential property manager calls you, what type of reference would you give? All right. I think, do we have another poll? I covered a lot in this slide.
Nope, not yet.
Okay. Let's go to the next slide, please.
Oh, there's
Oh,
our
great.
poll.
There's the poll. Okay.
Yep. This is Mary Beth. The poll is, what part of the housing application is posing a particular issue for the survivors you work with? So we just talked about barriers to housing and barriers to affordable housing, and how poor credit history, Nisha mentioned, is a really big factor. Go ahead and answer other particular issues, other particular parts of the housing application that is troublesome for survivors you're working with.
This is Brenison. I'm just going to read a few of the chat comments. There's some comments about how some rentals require 2 to 3 times their income. That's a big barrier. And that the same management company owns almost all of the affordable housing in their area. And substance dependence and how a client presents to a potential landlord can also be a barrier, as well as a requirement from private landlords to have an in-person meeting to even apply to rent, which can be especially challenging during COVID-19. There's some other comments about a subtle bias towards LGBTQ plus individuals applying for housing in some parts of the US. And then another comment of language limitations for applications during COVID-19 and adjusting to different age applicants. Thank you for sharing all of your comments.
All right, this is Kristen again. It looks like the fees, the application and fees are a barrier. Lack of required documents, frequently photo IDs, state IDs, driver's licenses, sometimes birth certificates are required, social security cards, and not having those documents can cause a significant time delay. And there's often a cost involved in getting those. So that is, assistance getting those documents is extremely helpful. Not having a bank account or negative rental history, we're going to address some of that as well. So yeah, on this slide, it talks about some of the most common documents needed, which I think we just covered. So in this next section, we'll talk about a security deposit agreement, the tenant selection plan, the application itself, and touch on the lease agreement a little bit. So there's a poll. What is your current level of understanding of the tenant selection plans? They could also be called tenant screening criteria, resident selection plans. Depending on the state you're in, they might have different, common names.
This is the interpreter. We're going to go ahead and switch to the other interpreter.
Thank you. Okay, so it looks like many of the people don't know much about them, so we'll touch on that and try to describe their use. So the tenant selection plan is something that any affordable housing property should have a detailed tenant selection plan. When you're looking at individual property owners who are renting a duplex, they might not have something as thorough as affordable housing properties will. But this will inform applicants of what the property qualification requirements are. So it's going to describe, you know, the things they look for in a background check. It'll describe occupancy guidelines. It'll have detailed information on, you know, different criteria too. If there's criteria to verify disability or sometimes, you know, sobriety or certain things like that. It'll also detail in there if there are requirements for verifying different levels of homelessness, long-term homelessness, chronic homelessness, and things like that. So this is something that an applicant can ask for prior to even looking at an apartment. If they're interested in living at the property, they can ask if the tenant selection plan should be emailed to them. Or can be emailed to them, because this is a document that is for the applicant that informs them how we're looking at their application. And once they have that information, then they can ask more specific questions on there. The language in them is often vague. So I think in the next slide, I have a sample of language that came from HUD subsidized property. And so it talks in here about a subsidized housing landlord may prohibit admission to an applicant to federally assisted housing if the landlord determines that the applicant is currently engaging in or has engaged in during a reasonable time before the admission decision. So a lot of that language is really vague. It doesn't give a specific time frame, and it says it may prohibit admission. So, and it tells the types of things they're looking at: drug-related criminal activity, violent criminal activity, and then just other criminal activity that would threaten the health, safety, or right to peaceful enjoyment. So this can be kind of frustrating too, because I think people really want to know the specifics, and that usually doesn't exist in this in the document, but it's a reference. So you know, if someone can read through this and say, yeah, I meet all of that criteria, I'm pretty confident applying here, then you know, that would be an ideal situation. When you go to talk to a specific property manager about the screening criteria, I think it's very common that people who have been denied frequently want to know if their application is going to be approved. And they will say, if I have this on my record, will you deny my application? And frustratingly, the property manager is required to say something like, I'm unable to determine whether or not your application will be approved or denied unless you apply and look at everything. And the reason they do that is because fair housing law prevents property managers from discouraging someone to apply. Everyone is welcome to apply for housing, and we rent to everyone who qualifies. Those are common statements that property managers are trained in when these types of questions come to them. The other side of that that's very frustrating, and that was mentioned by many people, is that application fees are very expensive. So like not having some sort of reference and idea before you apply for an apartment and wasting an application fee isn't really an option. So one of the, I'm going to see, yeah, the suggestions that I had is that if it hasn't happened already, if someone has experienced denied applications frequently, is to request a copy of that document if they haven't already. And there aren't that many different screening agencies. You know, there's usually a handful of them, and they usually report the same information. There are some inconsistencies there, but if you have one professionally processed screening criteria, it should provide a good basis of information on what's on your record. There's always the possibility that a different screening agency could come up with something different, but for the most part, that's a really good guide. And we'll kind of talk about addressing those items when we get to the denied applications. I think that's the next slide. Okay. And there's a poll. Have you worked with a survivor whose housing application has been denied? And if so, did you help appeal or ask for another review?
Nisha and Ani, this is Mary Beth, by the way. Nisha and Ani, if you want to throw anything in here about whether you've experienced working with survivors who have had their housing applications denied and what that was like for you and for them, feel free.
Yeah, this is Ani. I can share on that. I've definitely experienced working with people who've been denied on their application, and the appeal process is excellent. Sometimes I have to pause before that process and just work through the emotions that they're having, because a denial can be a pretty emotional thing and can be kind of devastating for a lot of women, and sometimes make them not want to apply again for other places, become really discouraged in it. So I kind of pause through that, and then just work with them on, do they want to do an appeal and how do we go about it? Yeah, that's what I'll share.
Great, thank you. So yeah, it looks like we have a variety of situations. Many people have not worked with a survivor whose housing application was denied. So that's great. That's the ideal situation if the applications are approved and that piece of it goes smoothly. If an application is denied, there should be a letter sent stating the reason for the denial and where you can get a copy of the report that you paid for with the application fee. In requesting this report, there are some various rules due to credit reporting laws, which I don't know all the ins and outs of, but I know when applicants have tried to request a copy of the application, some people had required that they request that by mail and that it gets mailed to them, which sometimes is problematic depending on where the person is at that time. There have been times when the reporting agency has been willing to fax a copy of the background check as long as the person was sitting right next to the fax machine. But just getting a copy of it can be challenging, so support in getting that information would be helpful. So if there is an opportunity to appeal the denial of the application, it should have information on the letter as well. Sometimes it won't be, so then I think it would be important then to ask the property manager if there is a chance to have other information considered in approving this application. On the next slide, we've kind of discussed some common reasons for denial, and you had mentioned many reasons too. Poor credit seemed to be a common reason, and I think within housing in Minnesota with supportive housing, I think credit is not as considered as much as it might be in other states or agencies. But that is a challenging, that's a challenging thing to overcome. It's not something that you can correct overnight. So some tools or resources to overcome that might be if that person can get assistance to provide a higher deposit. Sometimes people will make an exception if they put the first and last month's rent down or a higher deposit. And maybe having a conversation with the property owner to see if there is something that they would accept to overcome the poor credit on the record. On credit history, there might be information about money owed to another property owner or money owed to a utility company. Those outside of credit score are common reasons for denial too, because typically the resident would need to have utilities in their name at the new apartment. And I think it's just common practice for property owners to deny an application if money is owed to another property owner. So some things can overcome that as well if a payment arrangement is made with the previous landlord to, it might not need to be paid in full, but as long as they show that they're trying to pay that, that might be a significant reason to overturn a denial, but it depends on the place. The next slide. More common reasons for denial are if there's a criminal record that shows it would be a negative impact on other residents in the building and potentially affect their safety. Drinking and driving and public intoxication is taken into consideration at places where there's potentially a lot of larger families and people coming and going around the building. Income was something else that we mentioned, people not having the income adequate to cover the rent amount. 3 times the rent is a very common requirement, but I know in a lot of affordable housing properties, they will go as low as 2 times the rent or 2.5 times the rent. It's a really tough call to make because paying half of your income towards rent is challenging, and it's burdening someone with that expense. The other side of that coin is there's very little housing that is actually affordable. So, having that leeway to not insist that 3 times the rent is a requirement is necessary in a lot of situations as well. House size and the various program requirements could be a barrier as well, and that's one of the most frustrating things when there is a unit that meets someone's needs, but they don't have a specific disability verification or a level of homelessness criteria, age, or various other things that could be required for that specific apartment building. So the next slide goes into the City of Minneapolis renter protections that just came out recently. And they determined that the tenant screening was too strict and mandated that people reduce their screening criteria so that they're not considering misdemeanors with dates older than 3 years, felonies with sentencing older than 7 years. And then the third bullet point mentions a lot of felonies that many companies had as a lifetime denial offense. So various degrees of murder, manslaughter, kidnapping, first-degree criminal sexual conduct. Oftentimes people had in their screening criteria that, you know, if that happened in any year, it would be an automatic denial. So that's a significant change in Minneapolis. They've also reduced the screening criteria barriers with respect to rental history and credit history. And with credit history, it says that they cannot screen based on credit score, but can consider information in a credit report if relevant to the ability to pay rent. So I think the utilities and money owed to another management company or property owner would fall into that category. The other thing they state is that you can't screen out for insufficient credit history, so not having enough credit history. So those are some big changes, and yeah, I think it's important to get familiar with those, because people who were having experiencing frequent denials for housing might qualify now.
This is Brenton. Kristen, is this just for COVID-19, or will it continue past?
Yeah, this is outside of COVID-19. This is something that's specific to the city of Minneapolis. That's I can't remember the date that property owners and management companies needed to comply by, but I thought it was maybe the end of July. That so we did a lot of work to revise all of our tenant selection plans to comply with this. And at Common Bond, we made this not just specific to the city of Minneapolis, but did it across the board at our properties.
And this is the interpreter. We're going to switch and spotlight. Do it.
All right.
Share.
Thank you. Okay. This is Kristen again, on to appealing an application. I haven't been paying attention to the chat. Is there anything like specific that came up with appealing the application that I should concentrate on, or?
There is a comment from Claire, who has helped clients get their applications reviewed after a denial, but only with smaller landlords on Craigslist, not with any larger, not appealing applications with larger property management companies.
Okay. Yeah, I'll kind of address the reason for that in this section. So appealing an application, my advice in this area is to make sure you get a copy of specifically what the property owner was looking at when they denied the application. So in some appeals that I've received, people have sent letters and documentation about something that wasn't even on the report I was looking at. So I think that's the most important step, and it can be challenging, but it's really important. Then you're just addressing the things that they saw in making that decision. So the appeal can include a letter from the applicant explaining the event, or describing like why whatever was on the record won't be an issue going forward. It can be, you know, it doesn't need to be necessarily formal. It can be from the heart. Documentation that can be included are documentation of expungement of things that are on the record that still showed up. Any letters of reference from anyone, employers, case managers, family members, community members, probation officers, roommates, whoever. Achievement in any programs, job training, sobriety, personal advancements, goals, things like that. And then proof of any outside support, including financial support or ongoing case management support or things like that. So to address Claire's comment about being successful with smaller landlords, The reason for that is because they have much more freedom to make individual decisions, and properties that are under the umbrella of a large management company usually have much more detailed criteria on their application process. And the reason for that is that ultimately they're looking for documentation that explains why they went outside of their policies and procedures. So, you know, an individual landlord has a lot less policy and procedure manuals and things like that. And legally, a larger management company is taking a risk and is exposed in a sense when they go outside of their written policies. So, so yeah, when they say, yep, we're going to make an exception in this situation, even though our policy said this application should be denied, we're going to approve it, and this is why, because we have, you know, X, Y, and Z. So I know that's not specific, but that's sort of the thought and the reason for that. All right, we have another poll. I am most exposed to the intersection of domestic violence and housing when, and then there are a few options. This one's a short one, so I'll just read them. A survivor is searching and applying for housing. A survivor is trying to maintain housing. A survivor is trying to break a lease and seek safety, or something else. Right in the chat.
This is Brenison. Kristen, and there's a comment about what you were just speaking on with the smaller landlord. Abigail says, but also even with a smaller landlord, if they don't have explicitly written rental criteria and they deny an applicant, the Minnesota tenant/landlord statute dictates that landlords have to return the application fee.
I can't comment on that. My understanding is that typically the application fee is non-refundable, but what Abigail is saying that if they don't have explicitly written rental criteria and they deny an applicant, then they're not allowed to keep the application fee. I can't say whether that's, you know, I guess I don't know, but I will look into that, and it makes sense. Minnesota is has a lot of good supports for renters, so that makes sense to me. I've always worked at places that have had a tenant selection plan, so I haven't had it come up. Okay, so the poll results are in. I'm most exposed to the intersection of domestic violence and housing when a survivor is searching and applying for housing. We also have people who responded, a survivor is trying to maintain housing, and then lastly, a survivor is attempting to break a lease and seek safety. So one thing I will mention, we're going to address it, there's a slide for it later that addresses the Minnesota statute 504B, which has specific information about domestic violence victims in rental housing and breaking their lease. For those of you out of state, I won't be able to speak on that, but we'll touch on that in Minnesota a little bit. Domestic violence in rental housing. Some important points that I had on here are to know the lease agreement and all of the addenda. So some of the things that I've taken in here from leases are specific to a common Minnesota lease, but many management companies and individual property owners make their own leases, and they have specific criteria in that. it is possible that a property owner in Minnesota has written things into their lease, which the state of Minnesota doesn't support. So unfortunately, it kind of takes looking at that lease and then also investigating what the statutes say in Minnesota for housing law. Really important tip, request copies of every document that's signed. You know your rights. If something doesn't sound right, then there are legal aid resources that you can contact. And then also I wanted to mention that not all property owners, and honestly, even property managers who are versed in VAWA do not know all of the complicated laws and rules within this situation. I think at Common Bond, we have a protocol for, responding to these situations when someone notifies us of their rights under VAWA. And in the situations where someone's wanting to break a lease and get to safety, that one's the easiest. In many of the other situations where there is more than one person on the lease, we usually seek legal guidance ourselves. So. All right, so the next slide is the lease agreement. And this will typically describe occupancy and use. We're going to address unauthorized occupants in this section. It'll address damage to property, acts of third parties, and building rules and lease violations and addenda. All right, there's a poll. Have you encountered survivors and/or their abusers who have been deemed an unauthorized occupant by a housing agency or property manager? Yes, the survivor was labeled the unauthorized occupant. Yes, the abuser was labeled the unauthorized occupant. No, I have not encountered this, or something else right in the chat.
As you're answering that in the chat, I just wanted to point to the Minnesota Tenant and Landlord Handbook, which is, there's a link to that in the chat now. You can use that to find more information on tenants' rights under VAWA and tenants' rights in general in the state of Minnesota.
Yeah, that should have specific information about when and if an application fee is refundable. It was mentioned before. Okay, so it looks like there have been situations of all three where the survivor was the unauthorized occupant, the abuser was the unauthorized occupant, and then also people haven't encountered this. Slightly more common is where the abuser was labeled the unauthorized occupant. All right. So this is a challenging one. Unauthorized guests and occupants are very difficult to determine. So within rental housing, there are some rare exceptions where there is a front desk and people are required to sign in and out. But in the majority of situations, people come and go. Residents are able to invite whoever they like to their apartment, and frequently people stay overnight. So determining whether someone is living there illegally or just staying and visiting and staying overnight is very difficult. So some of the ways that property owners determine if someone is an unauthorized occupant, one, if the person is receiving mail there. 2, if the person has that property's address and apartment on their driver's license. And 3, if an outside agency informs that they are, that they have claimed that that is their home address. So occasionally we're notified of those things. Frequently, the property manager is notified that an unauthorized person is living in an apartment by their neighbors. And often a neighbor will constantly tell the property manager when someone is staying over there when they shouldn't be, or when the neighbor thinks they shouldn't be. So I think the most frequent way that this comes to somebody's attention is that there is a neighbor who is reporting it. So these next slides just go over some of the language that's in the Minnesota lease. And so I'm just going to kind of briefly talk about them. There's usually a clause in a lease that says management is not responsible for the actions or damages, injury, or harm caused by third parties, meaning guests, intruders, trespassers, or anyone who isn't under management's control.
This is Mary Beth. That is really relevant for survivors of domestic violence. Oftentimes, property damage is a method used by abusers to terrorize survivors. And so if property damage means punching holes in the walls of your rental property, the survivor could get evicted for that, for those acts of that abusive third party.
Yeah, we're going to cover that. And that would be a situation where the resident would notify the property manager of their rights under VAWA. This language here is just relieving management of responsibility for, damage or injury that happens to residents. I will mention that even though this statement is in a lease agreement, it doesn't prevent someone from exercising their rights. So this is a very simple blank statement, but the complicated nature to whatever damage or injury or other item that happens tells another story. And so there are always, resources for residents to look to legal aid for advice when specific situations come up. So this next slide is talking about trespassed persons, but Mary Beth, what you were just talking about, damage to property, is the slide afterwards. So maybe I'll just jump ahead to the damage to property slide. So here's some also general language in here. So often this comes up where there's a question as to who's responsible when there's damage related to domestic violence. And the answer is, I don't know. Everything is situational and it depends. Some language in the Minnesota lease says that resident promises not to damage or misuse the apartment or allow guests to do so. Resident promises to notify management immediately of conditions that are dangerous to human health, safety, or which may damage the apartment or waste utilities. And then also resident shall reimburse management for any loss, property damage, or cost to repair or service caused by negligence or improper use by resident, his, her, agents, family, or guest. So this is language from the lease, and often property managers will use this language when there is damage to a property to say, here's an invoice. You're responsible for this damage that we had to repair. Often, I think people, when I've had these conversations before, people have asked me, can they legally charge for damage? The answer is, I don't know. Do they do they charge for damage in these situations? Yes. Do they always? No. I think, you know, depending on the situation, residents will have conversations with their property owner or manager, and the outcome could be different in every situation. So some of the resources that residents have are to notify the property manager of their rights under VAWA. They can contact Homeline, which, you know, has specific housing law knowledge, and they can help support and review documents that they've been given and see if they fall within the law. And then with respect to damage to property, there's also an option for them to put their rent in escrow with the court and challenge the property owner to either repair the damages or the rent payment is held until there's proof of those damages being repaired. So in this section, I think there's probably, are there questions or specific situations that anyone wants to talk about?
Kristen, this is Ani. I will add an odder scenario that I wonder how many other people have encountered, where a survivor had secured her own place to live, but did still have the father of her child visit very, very often. And the landlord, for various reasons, wanted to require her to put him on the lease, but she felt much more protected of her rights when he wasn't. And she felt threatened by the landlord when they said he's over more than 50% of the time he has to be on the lease. And her housing worker helped her read through the lease, where the actual qualifications were that he had to be there 5 nights in a row, and he didn't stay over that often. So that's an example of landlords and property managers not always knowing what's in their own lease, not intending to re-victimize someone, but ending up doing that. But a shout out to the housing worker and to the survivor for knowing herself and knowing her rights and making things secure for herself.
Yeah, that's a really good situation to point out. You just made me think of something and I'm losing it. Oh, I know what I wanted to say. So in these situations, when someone's being accused of having an unauthorized occupant, it's so difficult for us to know who, as a property manager, who's staying overnight when. Like, it's like the documentation of that is just really challenging and problematic. So so yes, I think in every situation, regardless of whether it's in the lease, it can be challenged, it can be questioned, and it can be reviewed. And because leases are written in a way that there frequently isn't specific information like that, like no one can stay more than 5 days a week, there's a lot of room for questioning and asking for specifics. So
This is the interpreter. We're going to go ahead and switch interpreters and spotlight the other interpreter.
okay, thank you. All right, this is Kristen again. Any other questions on that? Okay. So just to jump back to trespass persons, this is another complicated situation, and there are a few different situations. The first situation I listed is an official trespass through the police department. typically, and this is specific to Minnesota, typically that would require someone from the police physically serving someone with paperwork that lets them know that they're trespassed from the property and that they're not allowed anywhere on the property or in a specific apartment. These are really rare. One, it's rare that the property management person and the police and the person who they're interested in trespassing would be there at the same time. So it usually doesn't happen that way. The second situation is a notification from the property owner or manager to say that because of X behavior, this person is trespassed from the property. Sometimes it will say, if you allow this person to come back to the property, you may be in violation of your lease. And then because the property is private property, the property owner does have some rights in trespassing individuals. The other side of that is that the resident also has rights with respect to their guests. And so this is another one of those really gray areas and a situation where the resident can talk to someone. If someone has been trespassed that they do not want trespassed, then they have a right to have a conversation about that and request that it be overturned or reviewed. With respect to domestic violence, frequently the resident will want someone trespassed from the property, but with working to keep that person away from the property is problematic. So I think the tension between property managers and survivors or victims of domestic violence is that when the person who's trespassed comes to the property, if the resident is fearful and is afraid of what will happen if they don't allow them into the property or into the apartment, that can be looked at by the property manager as violating this trespass agreement. So I think that is that's really a great situation where the resident would inform the property manager of their rights under VAWA in that situation. All right, so we did damages. Another thing that I wanted to cover in here is management's responsibility with damages. There's language that I saw in a lease that says management promises to maintain the apartment in compliance with applicable health and safety codes, except when caused by intentional or negligent conduct of the resident or his or her guests. So there's language in a lease. I would say if that language led to a situation where management said they weren't responsible to repair the damage, I would question that, because ultimately, having things function in the apartment is a requirement of the lease and something that management is required to repair. The other side of that is, depending on the level of damage, if something is so damaged that the apartment becomes unlivable, where it's not safe for someone to stay in that apartment anymore, there's frequently language in the lease that the lease is terminated immediately. And if the manager or management chooses not to restore the apartment, then the lease would end. It would be an unlivable apartment, and so the resident would have to leave, essentially. Typically, if an apartment became destroyed to this level, if there was another apartment available, that could be made available for the person to transfer into, but that isn't necessarily the case. So I don't know if anything has gotten that, if anybody's experienced anything getting to that level with damage, frequently it's a window or a door. If a door is so damaged that it can't be secured, that could potentially fall into that situation where the apartment is unlivable. All right. So we have another poll. Do you understand the process of terminating a lease due to domestic violence? Yes, I understand this process well. I have some familiarity with this. I would really like to know more, or I don't know much about this.
Kristen, when we're talking about terminating a lease under VAWA and notifying people's property owners of rights under VAWA, does that notification have to happen in written form, or can you just tell the landlord, I'm invoking my rights under VAWA? How does that work?
You know, that is a really good question. I think in the direction from HUD, it does reference a written document. So let me see if I can find that. So with the HUD information on VAWA, they supply a form, and frequently property managers will request this form. And the form notes things, you know, the date of the request from the victim, the name of the victim, and they also request the name of the accused perpetrator, but only if that can be safely disclosed. So the resident has an option, you know, to not disclose that. Then there's a description that's required about the incident. So they're notifying, I'm a victim, and are required to provide some sort of information to the property owner. I don't know if it has to be in writing. Typically, if a property manager is notified at our properties, they would request, say, hey, I can provide you with a document. Can you fill this out? If someone refuses to fill it out, I'm not sure what the legal ramifications are of that. It might mean that, actually, I don't even want to speculate. I don't know. I think best practice is to document it in writing, and really in everything between residents and property owners, having everything in writing, either in a paper document or via email, is the best practice.
Thank you.
All right, do you understand the process of terminating a lease? 15% said yes, 26% have some familiarity, and 41% I would really like to know more. 19 said I don't know much about this. Okay, so my knowledge in this is pretty specific to Minnesota, or it's very specific to Minnesota. So for people who are states, I'm not sure what the you know, what the housing laws in your state say. So the first step would be notifying the property of rights under VAWA, and best practice is to do that in writing. When it is an affordable or federally financed property, that may be the requirement to use that HUD documentation. But again, I would defer to a lawyer in that situation. When terminating the lease and exercising your rights to terminate the lease under VAWA, there are some things that are important to clarify. Clarifying rent responsibility and when it ends and what's going to happen with the security deposit is important. Minnesota statute 504B has specific direction, but there's also some vague areas in the way that it's written. Another thing I recommend is clarifying the rental reference. If you are breaking your lease under VAWA, that would be considered giving proper notice in Minnesota. So if you do it in accordance with housing laws written, that would be given proper notice. Even though the lease agreement says there's a 2-month written notice to vacate required, there is an exception for this situation. So clarifying that rental reference, again, property managers do need to be informed of a resident's rights under VAWA. Understanding any balance owing for charges, cleaning, damages, those would be outside, the rent responsibility. The other thing that's important to clarify is with the termination of lease, there is belongings in an apartment. So from a property management perspective, we expect everything to be out of the apartment and for the apartment to be cleaned to receive a deposit back. In a situation where someone is fleeing and needs to leave quickly to be safe, that complicates things. So clarifying it. If there is a situation where someone isn't going to be able to move specific things or address some of those other things in the lease, they will need to clarify. Potentially, they wouldn't necessarily need to be present for a walkthrough, but have a conversation with the property manager to say, I've left the apartment, I'm not coming back, please go inspect it, and then let's have a conversation about what you understand would be charged to deposit or over the security deposit. And then when these conversations happen, I'll say it again, get it all in writing somehow. If you have a conversation over the phone, or if someone you're working with has a conversation over the phone, follow up with an email to the property manager or owner just to say, hey, we just had this discussion. Can you confirm this, this, and this? And then, ask them to respond and confirm that, yep, that's what you've agreed upon. If something can be documented in writing that you both sign, that's ideal, but getting something clarified somehow in writing is the best practice. The next slide goes into domestic violence, tenant protections, and rights. So with the Violence Against Women Act, that protects applicants, tenants, program participants from being evicted, denied housing assistance, being terminated from housing based on acts of domestic violence. This applies to HUD subsidized properties, federally funded properties, and any properties that have federal funds or HUD funds are subject to these laws. So there may be market rate properties that have HUD funding that are subject as well. In rental housing, VAWA information has to be kept separate from the resident file. And this is a requirement in the event that an abuser is also a leaseholder and potentially has access to the information in the file. The VAWA transfer policy This is usually written into the tenant selection plan, and it's based on the availability of a similar unit or a like unit. And what that means is, I'll use a project-based Section 8 property as an example. So for a transfer to happen from a project-based Section 8 property, there would need to be a unit available of similar size with the same Section 8 program at a different property, or potentially within the same property if that's something that the resident requested. But typically when fleeing domestic violence, then it would be in a completely different property. Those units don't come up very often, so that's one of the more challenging transfer situations to negotiate. But if there is a unit available that would qualify as a similar unit, then that resident is allowed to, is given preference over everyone else on the waiting list at that other property. So the next person who was in line to move into an apartment at that property, the person who is transferring due to VAWA would have priority for that apartment, as I understand it. So with Minnesota Statute 504B, this has specific information about the rights of victims of violence to terminate their lease. And in this statute, it does state that written notice must be delivered before the termination of tenancy by mail, fax, or in person, and it needs to be accompanied by a qualifying document. So the landlord, it states in there that the landlord may request specific information about the abuser, and the resident has the right to refuse that information. The other thing that this statute states is that a tenant who is a sole tenant and is terminating the lease is responsible for the full month of rent in which the tenancy terminates. So essentially, when that resident, if that resident notifies the property manager on August 31st that they're terminating the lease, the way this is written, as I understand it, then that resident's rent responsibility would end August 31st. And assuming they had already paid August rent, then their rent obligation would be done after that. It does state that the property owner can keep the security deposit, and that it doesn't talk about what will happen with cleaning charges and damages or things like that. The situation where this gets complicated is one with what I talked about before, belongings in the apartment, and what does it mean to vacate or terminate the lease, and whether or not there are other leaseholders in the apartment as well. And those are both situations where we would consult lawyers to help us navigate that. Any questions or comments on those policies? I feel like women's advocates would probably have more detailed information on this as well.
This is Ani. I see that Brenison and Sonia shared some great links in the chat, specifically about this process, but also to remind, I think we have a lot of domestic abuse advocates on here tonight, and in Minnesota, you are the qualified, you're someone that can fill out the documentation to say that there's a domestic abuse situation and this person needs to leave the lease. And you'll find that document in those that are put in the chat.
Great, yeah, thank you for mentioning that.
This is the interpreter. We're going to go ahead and switch and spotlight.
Great, thank you. Okay, this is Kristen again. The next slide we have is communication with property owners. And this is just recommendations potentially to get guidance from a case manager or legal aid representative prior to communication with the property owner. If that's possible, that's an ideal situation. And then again, to get everything in writing, agreements that both the resident and the property owner sign are ideal in these situations. I think it's easy, you know, months down the road for people to forget the conversation that they had. So having documentation of that is important. All right, we have another poll, and this next situation, or this next section, is about navigating specific situations, and we've broken it down to 3. So the question is, which of the following situations would you like to learn more about navigate? Both the victim and abuser are leaseholders. 2, the victim is the leaseholder and the abuser is an unauthorized occupant. 3, the victim is not a leaseholder, but is living in the apartment. Or 4, something else right in there. Somebody said all of the above.
Yeah, these are 3, this is Mary Beth. These are the 3 most common situations for domestic violence advocates who are working in specific situations in housing. So I think the one that most people, that is the top of the chat, that most people want to learn about, we're going to spend the most time on, and then spend whatever time is left on the other 2.
Okay, perfect. Yeah, so 32% said both victim and abusers are leaseholders. 26, the victim is the leaseholder and the abuser is the unauthorized occupant. And the last one is the highest percentage, 47, the victim is not a leaseholder, but is living in the unit, apartment. All right, so it's 7:33. I think we can cover each of them, but it looks like the situation where the victim is the leaseholder is one that we can spend a little less time on. Okay, so situation 3. The victim is not on the lease, but is living in an apartment with the leaseholder. This is the most challenging situation because so there may be rights in other states. A lot of what I'm going to talk about is how this situation has played out in Minnesota. When I have encountered this situation, the victim doesn't have a legal right to the apartment or to their belongings inside the apartment. So the property owner or manager can't legally give the victim access to the apartment to access their things if they are locked out of the apartment. In some of these situations, we have tried to, or they have tried to involve the police to help get access to the apartment and get their belongings. But if the person who's in the apartment, the abuser is in the apartment and has locked them out, the police are unable to force entry and they're unable to help the victim get their belongings. this is absolutely the most challenging situation to navigate, and frequently, as you know, it's an intentional power dynamic situation where the abuser is holding significant items, a purse, a phone, clothing, money from the victim, and it can be really challenging. Depending on the situation, there might be situations that the property can address as lease violations. If it's simply not letting someone into the apartment, there's not a lot that property management can do. Has anyone else had a good resource or tool that they've used in this type of situation? Yeah, it's really challenging. I think if from a property management perspective, we've had success in this situation, it's because of the relationship that property management potentially has with the leaseholder, where they can say, you know, that this situation has become an issue, it's become disruptive, if that's been the case, and can potentially convince the leaseholder to allow the person to access property. Sometimes they've been willing to do that with the property manager present to, you know, be there with both of them to make sure the victim gets, you know, the basic things that they need at that time. But frequently there's many other items that are left in the apartment that they're just unable to take in an individual situation. The victim does have the right to take the abuser to conciliation court and try to, you know, get a judgment and get their belongings back. But that doesn't help in the situation where someone's phone and purse are in the apartment.
This is Mary Beth. Claire mentions in the chat doing an OFP, getting an OFP processed and filed so that the courts can order the police to help the victim get their belongings out of the unit. I don't know how successful that is. I don't know what the success rate of that is, but I imagine it is a tool.
Yeah, I'm not sure how that would work out. Claire, if you have any other information on that, like that would be helpful. Any other questions on that situation? All right, so then the next situation was the first one where both the victim and the abuser are leaseholders. So there are a few options in this situation. In this situation, both people have equal right to access the apartment from a property management perspective. So one person can't lock the other person out. The ideal situation here is that one person agrees to vacate and the other person signs a new lease without the second person on there. And that can be either person, you know, depending on who, you know, who would like to stay in the apartment and who would like to leave. There can be a mutual termination of lease agreement where both parties agree to vacate and leave the apartment. And then a third option is I said eviction and bifurcation, but essentially it's just a bifurcation of the lease agreement. And it would be taken to housing court, similar to an eviction. And what we would request from the court would be that the victim would be allowed to stay in the apartment, and that the abuser would be asked to vacate the apartment by a certain date. So again, I said an eviction is filed, but it's essentially a court action to bifurcate the lease and essentially evict the abuser. In court, it's requested that the abuser is evicted and that the property owner and victim can enter into a new lease agreement. The court record for that can be expunged. An agreement can be made to expunge the record of both parties. And another, within the leaseholder may be, leaseholders, so adults who are on the lease, may be responsible for court costs in accordance with the lease. So knowing that sometimes will help convince one or both parties to enter into a mutual agreement that's done outside of the court. So it looks like Claire has added more information. So I'm just going to read what Claire has written here. I've done an OFP so that the courts can order the police to help out. I've done it in the past where the court order has stated that the city police need to accompany the victim into the home to get personal belongings. I've had success with this before. The court order will also typically say that they can gain access specifically for retrieving their belongings. Claire, can you say what city or state that happened in? Were you in Minnesota? And then, oh, Hennepin County. All right. So that's good information. It's a good option. Granted, it takes time. So going through that process won't help immediately, but yeah, one resource for another tool. Any other questions on situation one where both the victim and the abuser are leaseholders? All right, I think we can go to the next slide, situation two. So this one intersects with the previous conversations we've had with unauthorized occupants and trespass notices. So this is one where the victim is the leaseholder and the abuser is an unauthorized occupant. The abuser can likely be trespassed, either an official trespass with a police officer if possible, or an unofficial trespass. The leaseholder can request that the locks are changed at their expense, and typically that can happen pretty quickly. Regardless of whether the unauthorized occupant's belongings are in there, we would never be able to give that unauthorized occupant keys, as in the first situation we discussed. So things to note in this situation, that if there is an admission that the person was living in the apartment and they wanted them trespassed, it is possible that they could be given a lease violation for that. Admitting that they allowed a person to live in the apartment doesn't prevent them from being able to acknowledge that as a situation where they're a victim of domestic violence. So just because it could be a lease violation doesn't mean that it doesn't also fall under potential protection under VAWA. The leaseholder agrees to do what they can to, well, hopefully the leaseholder will agree to do what they can to keep the abuser away from the property. As I mentioned before, requiring someone, a leaseholder, to do this without also understanding situations where they might not be able to do that, where they feel fear for their safety and are unable to prevent someone from coming to the property, needs to be acknowledged, and that may be something that a situation that a property manager wouldn't necessarily understand or be familiar with. Safety planning with the leaseholder is essential. Typically, property managers aren't involved in that process. They can be, and there are, you know, certain things that they might be able to help with, but yeah, I think that's something that we're a piece of the process that property managers are typically removed from or don't have a lot of involvement in.
Yeah. This is Mary Beth. Kristen, I was going to add, for property managers aren't usually involved with the safety planning with the leaseholder, like you said, but in this situation where the abuser is trespassed from the property, and the victim is the leaseholder, in a situation of domestic violence, if the abuser is trespassed, they still know where the property is, right?
Yep.
So the leaseholder can do everything that they can to keep the abuser away, but it's important as advocates that we're engaging in safety planning with the survivor, because even though the abuser is disallowed from the property, that's not to say that they aren't going to show up, right? So we have to do a lot of really intense safety planning there in case the abuser does come back and does trespass.
Right. Yeah, and frequently that is the case. And so one of the few responses we have to that is involving the police. And involving the police can be problematic for many reasons. And regardless of whether the resident wants that person to stay away from the property, they may have obvious reasons for not wanting to involve the police in that process too. So just issuing a trespass rarely solves the issue, or gets rid of that need for safety planning. So I'll defer to Nisha and Ani, because there might be more like specific support feedback that you would have in that situation that, like, as property management, we wouldn't necessarily be involved in. Also, you might just have like recommendations or experience navigating that those safety issues with a property manager, or if anyone does.
This is Ani. One possible option, it definitely takes time, is again, like you discussed, the transfer. So if this is a property manager that owns multiple units and the abuser has been trespassed but is still a threat, can the leaseholder be moved to another property where the abuser wouldn't know where they were? And then again, as Mary Beth said, it's intense and sometimes creative safety planning. I would certainly appreciate when a landlord or property manager is aware of situations and is supportive of the survivor. That's really helpful, especially when they understand why the police might not be something that the survivor wants involved, different preferences that they're going to have. So supportive landlords and property managers are very helpful.
Yeah, very appreciated.
This is the interpreter. We're going to go ahead and switch and spotlight the other interpreter.
All right, thank you. All right, this is Kristen again. Any other questions on any of the situations we've brought up? We've still got some time, so I will turn things over to women's advocates, and I'll be here too if there's any other questions or anything else I can help with. Thanks everyone for being here tonight, and thanks to women's advocates for letting me be a part of this presentation.
This is Mary Beth. Thank you so much for being here, Kristen, and for sharing your expertise with us. On this slide, there is just a whole bunch of housing resources with links to organizations that specialize in tenants' rights, in housing law, in rental assistance, outreach, just the whole smorgasbord really of tenant landlord resources for Minnesota. So if you get a minute, you'll get a PDF of this PowerPoint in your emails after the presentation. So if you do get a minute, I would spend some time looking at these resources because these are all really good spots to learn about different aspects of housing and domestic violence and receive assistance. It's important, I think, as advocates to have a really deep toolkit of resources that we can hand out and connect people with as we're working with them. And so taking some time to look over these resources and seeing if there's anything new that you haven't, that you don't know about but would like to know more about, or that you haven't considered connecting your clients with. Just go ahead and take a look at these. Let's see, if anybody's got any questions or comments or anything in our remaining couple of minutes, please go ahead and put them in the chat. We will be sending a post-webinar survey to you soon. We will also, like I said, be sending this PDF of this presentation to your emails. So you should get a copy of that, and we'll have a recording available on our website. We also have a bunch of other webinars coming up this month and events coming up this month. We have another webinar happening next week about stalking, where you can register for that. We also have another conversation happening called Building Resiliency as a Foundation for Perseverance. That's going to be a conversation happening online as well. Another event that we're having later this month is a virtual book talk with the author Kelly Sundberg to talk about her book and her story. And then on October 15th is our emergency response virtual benefit, our virtual fundraiser for women's advocates. So in the chat, you'll see a link to the post-webinar survey. Go ahead and tell us what you think of tonight. We would love to learn more. We also have a link in the chat to register for all of those upcoming events that I just mentioned. We'd love to see you more often. We would love to see you at all. We love connecting with you all and telling you what we know and sharing our experiences and getting to learn of all of your experiences as well. Thank you so much for being here.
This is Kristen. I just noticed somebody has their hand raised in the attendees
Ooh.
Looks like there might be a question.
Well, if you do have a question, Sue, with your hand raised, go ahead and put it in the chat. We would love to hear from you. In the meantime, thank you all so much for being here. This slide has a link to all of our contact information, emails for our housing advocates. To request a certificate of attendance for tonight, please go ahead and email outreach@wadvocates.org. And just put in your subject line and then in the body of the email that you're requesting a certificate of attendance for this particular webinar. We also have a crisis and resource advocate email. If you find yourself needing resources or support, you can contact me at resources@wadvocates.org and I will do what I can. We also have a housing specific webpage on our website, so feel free to check that out as well. And again, this is Kristen's contact information at Common Bond as well. Well, thank you all so much for being here tonight. I think we are, if everybody is done asking questions, I think we are all good to go. So Kristen, I wanted to thank you so much for all of your expertise and spending this time with us tonight. We're so glad to have you.
Thank you, my pleasure. Thanks everyone else for being here and have a great night.
All right. Well, thank you. Have a great evening, everyone. Thank you to the interpreters. Thank you to Ani. Let us know. We have our emails if you have any follow-up questions, but I'm going to go ahead and end the webinar. So thank you.